So we've all seen Florida Man, but I'm beginning to think maybe we need to start thinking about Wisconsin Man. I'll have more on that thought in just a moment. Well, it's interesting to me some of the things that go on in Wisconsin and don't really seem to get reported much outside the country. A viewer asked me about a case that I had not been familiar with out of Wisconsin involving a guy by the name of Chandler Halderson. Now, Chandler has been convicted of two murders, and the circumstances of his case are pretty outrageous. Apparently, he had worked up a pretty decent fantasy life about going to college, getting a degree in IT, and going to work for Elon Musk. Unfortunately, he wasn't going to college, he wasn't working on an IT degree, and Elon Musk doesn't hire people who don't have degrees. So there was that. The the problem for Chandler all came down to the fact that he was a college student living at home who wasn't going to college, and I guess at some point mom and dad found out. So when mom and dad found out, they did what every parent does when they find something like that. They say something to the effect of, you either get in college and do your work in college, or you're going to have to find another place to live. Apparently that didn't sit too well with old Chandler, and Chandler took a page right out of Lizzie Borden's book. He not only killed both of his parents, but in addition to that, he wound up, shall we say, separating them in death. Well, parts of them. It's pretty ugly. I won't go any further than that, but to say that it's a pretty awful case is an understatement. Good old Chandler then decided that maybe it'd be a really good idea if he kept the fact that he had killed his parents from everybody else. So when people started calling him saying, hey, we haven't heard from your mom and dad, he kept telling them, well, they went up north to the cabin, which was an old place that had been passed down through the family. And he kept telling them that until somebody went up to the cabin to see what was wrong with mom and dad, and they weren't there. So then he started going around to the neighbors and asking them, hey, have you seen my mom and dad? And of course, nobody had seen his mom and dad because they were planted in a couple of different places where Chandler had left them. So it really was a truly egregious case. So in Chandler's case, he goes to trial and he has a nice trial, and sure enough, they convict him. And like everybody who has ever been convicted in a trial, he comes to the state and says, I need a public defender to file an appeal for me. But that's where things really get interesting. And I really wish we had this rule in Missouri, because I think it is a really, really good rule. And basically, there is a rule in Wisconsin that allows for an attorney appointed to represent someone who is indigent to file what's called a no merit report on an appeal. What that means is that the attorney has reviewed the transcript, he's talked with his client, he's listened to any issues that the client wants to raise, and he's looked at the transcript regarding the issues that were raised at trial, and he's made the determination that there is no merit to pursuing an appeal. Now, if this were a privately paid client, the attorney could simply withdraw prior to filing the appeal. But since this is a safety valve for the benefit of people who are indigent in Wisconsin, they have a whole procedure for no merit appeals. Let's take a look at that right now. This is Wisconsin Rule 809.32. It says, if an attorney appointed under 809.30 or Chapter 977 concludes that a direct appeal on behalf of a person would be frivolous and without any arguable merit within the meaning of Anders versus California, a notable Supreme Court case, and the person requests that a no merit report be filed or declines to consent to have the attorney close the file without further representation by the attorney shall file with the Court of Appeals a no merit report. In Anders, the state of California dealt with this similar issue. There, the appointed counsel reviewed the record and filed a statement with the court saying that in his opinion there was no merit to any appeal, and as a result, the court allowed him to withdraw. The client wanted to file an appeal pro se, which he did, and then after his conviction was affirmed, the next step that happened was he took a writ of habeas corpus to the Court of Appeal, to the district court, the federal district court in California, and the federal district court denied his relief. The Court of Appeals for the Ninth Circuit denied his relief, and the United States Supreme Court said, time out, guys, that's not how this is going to work. If you are going to deny someone the right to file an appeal with counsel, then you have to provide that counsel, and if that counsel decides that there is no merit to the appeal, he can't just file a letter with the court and say, I'm not taking this up. And the court set out certain procedural safeguards to make sure that the indigent's right to counsel was guaranteed. That all started with a case called Gideon versus Wainwright. It's a very famous case. You can go look that up. I may even want to do a video on that at some point, but basically it guaranteed the right to counsel in criminal appeals, which is why in the rule here where it cites Anders versus California, it is telling counsel you have to do this because of the Supreme Court's rules in Anders versus California. The no merit report shall identify anything in the record that might arguably support the appeal and discuss the reasons why each identified issue lacks merit. The no merit report shall comply with the form requirements, and it shall not exceed 50 pages or 13,000 words. So, counseling and notification. Prior to filing the report, you have to discuss all potential issues identified by the attorney and the person whose appeal you're filing, and shall inform the person that he or she has three options: to have an attorney file a no merit report, to have the attorney close the file without an appeal, or to have the attorney close the file and proceed without an attorney or with another attorney retained at the person's expense. The attorney shall inform the person that a no merit report will be filed if the person either requests a no merit report or does not consent to have the attorney close the file without further representation. The attorney shall inform the person that if a no merit report is filed, and the attorney will serve a copy of the transcripts and the circuit court case record upon the person at the person's request. Then the attorney has to prepare a certification on that issue. And here is what that report or what that certification says. Basically that he explained the options and he's informed his client that they may file a response to the no merit report, and that I may file a supplemental no merit report and affidavit or affidavits containing matters outside the record, possibly including confidential information, to rebut allegations made in my client's response to the no merit report. So that gives the attorney the right then to do something that is somewhat unusual, which is breach the confidentiality of the client in order to explain why there is no merit to the appeal. As I've said before, an attorney has a duty of candor to the tribunal, and he cannot allow his client to lie under oath. And then this is the statute and the remainder of the statute where it talks about the service of the no merit report on both the client and on the Court of Appeals, the response to if the client decides to file one, the supplemental no merit report that rebuts anything from the client's response, and the idea that if there needs to be, there can be a remand for fact-finding prior to the Court of Appeals determining that there is no merit to the appeal. In Chandler Halderson's case, he has effectively been had granted relief by the circuit court already, in that the court determined that he shouldn't have been convicted of mutilating a corpse and hiding the bodies. For whatever reason, the court found that that was inappropriate, but he didn't touch the murder convictions. So apparently the attorney who is representing him filed for a no merit report, and it has basically there's a time deadline for that Halderson has to reply, and as of today, I haven't seen anything that came through there. But this raises a really interesting question. And the really interesting question is, what's going to happen in Darrell Brooks' case? You know, if there was ever a case where there is grounds for a no merit appeal, it would have to be Darrell Brooks' case. His sovereign citizen nonsense in the courtroom, his antics in the courtroom, his ridiculous displays of petulance in the courtroom, and the judge's very patient, very eloquent way of dealing with him, the fact that although she could have found him in contempt, which would have been meaningless given the fact that he was looking at life, even though she could have taken it out and gotten angry and done things that would have indicated that she might have been prejudiced against him, she kept her cool and she didn't do any of that. And as a result, the attorney who will represent him on appeal will have to analyze, in essence, two real issues. One, whether the appeal in general has any kind of chance of success, which I doubt. And two, whether he should have been allowed to represent himself, given his predilection toward obstreperous conduct and just ridiculous outbursts at the court, staring the court down, telling her she didn't have any honor, demanding that she prove jurisdiction, all of this. If I were representing him, I would certainly do a very thorough review of the record. I would seek extensions of the deadline if I needed to make sure I got all of the evidence covered. And then basically you have to look at what he was convicted of. He was convicted of homicide. And is there any chance that there was a mistake? Is there any chance that there were errors in getting any of the evidence in? And I don't think there is. Now, there might have been some minor deviations, some things that, you know, in retrospect, maybe they were, even if they weren't relevant, the prejudicial value was greater than the probative value. There might have been a few of those, but at the end of the day, the prejudice has to be so significant that it suggests that the jury made a decision on an emotional basis and not on a factual one. And I don't see that happening in this case. And I hope that the attorneys who represent him on appeal will do a good job and will not allow him to game the system. Now, of course, as you saw in the statute, he has an opportunity to file his own appellate brief. Whether or not he takes that option is anybody's guess. But if he does, again, I don't look for there to be a whole lot of merit in anything that Darrell writes in his case. So I want to thank the person who brought this no merit issue to my attention. Like I said, I think this is one of those things that almost every state should employ. It would reduce the burden on appellate defenders. It would reduce the burden on the courts. And there would be very little likelihood that anybody who was truly innocent would scrape by without getting a fair shake under any of this. So, if you have any questions, let's leave them in the comments down below. Like, share, subscribe, you know all the stuff we ask you to do. Again, if you have the opportunity today, go out of your way and do something nice for someone. Making the world better one act of kindness at a time is something that I want to have carved on my tombstone. You have a terrific day, and I will catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.